At 6 a.m. on a Tuesday, I drove to the road entrance and hung a gate, not as a threat, as a fact. I'm a contractor, 35 years. I own the 3-acre parcel where the only road into a 58-home neighborhood crosses my land. The HOA has used that crossing since 1974. Last winter destroyed the road. I repaired it. Culvert replacement, base work, new asphalt. $49,500. I sent proper notice. I submitted documentation. I invoiced the HOA for their half. The maintenance agreement from 1989 is 4 pages. Section 3 says, notice before, documentation after, reimbursement in 45 days. The board said the repair needed prior approval. I read that agreement when I bought the property in 2004. I wrote one note in the margin on Section 3. Notice required, not approval. The board voted twice to refuse payment. Their own attorney told them the argument was weak. The judge agreed Friday morning. The gate went up Tuesday. Day 9, they paid. Let's set the stage. Before we jump in, I'd love to hear where you're tuning in from, so leave a comment and hit like and subscribe. Leonard Koss had owned the parcel at the Hardin Cove Road entrance for 19 years. 3 acres of mixed timber and cleared frontage, at the point where the county road ended and the private road began. The land sitting at the lake community's single point of connection to the public road system, like a hinge between 2 different worlds. He had bought it in 2004 for reasons that had nothing to do with the road. He had wanted the timber acreage on the parcel's northern half and the cleared section on the south for an equipment storage yard. The practical requirements of a man who had been running a heavy equipment contracting business for 15 years and needed ground to park machines on without paying commercial lease rates. The road had been incidental to the purchase. It crossed the parcel's southern edge for 340 feet, entering from the county road at the western property line and exiting at the eastern boundary, where it met the Hardin Cove HOA's community gate. It had been crossing the parcel since 1974, when the original Hardin Cove development had been laid out and the road established as the community's sole access corridor to the public road system. The 1989 maintenance agreement had been negotiated between the parcel's prior owner, a man named Garrett, and the Hardin Cove HOA's board. Garrett had grown tired of maintaining a road that 58 households used daily without contribution, and had engaged an attorney to formalize cost sharing. The resulting instrument was 4 pages, recorded against both parcels in the county deed records, and had governed the road's maintenance for 34 years when Leonard received Sylvia Trent's refusal letter in April 2023. Leonard had read the agreement when he purchased the parcel in 2004. Standard practice for a contractor who understood road maintenance costs, real money, and that any instrument governing cost sharing needed to be read before he signed the purchase agreement. The agreement was straightforward. Maintenance costs split equally, 50% each. The party initiating a repair provided written notice to the other party before work commenced, submitted documentation of completed work afterward, and the receiving party reimbursed within 45 days of the documentation package. The agreement covered routine maintenance and structural repairs without distinguishing between them in the cost-sharing provisions. It required notice. It required documentation. It required reimbursement within 45 days. It did not require prior approval. Leonard had noted that in the margin of his copy when he first read it in 2004. Notice required, not approval. He had kept the copy in his contractor's files under a tab marked Hardin Cove Road, Maintenance Agreement, 1989, and had referenced it twice in 19 years without incident. Once in 2009, when he had repaired a drainage pipe and the HOA had reimbursed him within 30 days, and once in 2016, when the HOA had resurfaced a section near the gate, and Leonard had paid his half within 3 weeks. The arrangement had worked without friction because both parties had read the agreement the same way and acted accordingly. The winter of 2022 to 2023 had been the county's wettest on record, 11 freeze-thaw cycles between November and February, the ground saturating and refreezing in alternating weeks, the soil below road bases throughout the county expanding and contracting with each cycle. The county road department had posted spring load restrictions in March. Private roads, not subject to county maintenance, had absorbed the damage without mitigation. Leonard had walked the Hardin Cove Road on the first clear morning in March, Tuesday the 3rd, the temperature above freezing for the 5th consecutive day. He had walked from the county road entrance east toward the HOA's gate, assessing the surface the way a man with 35 years of road construction experience reads a road. Methodically, edge to edge, reading the surface for what it said about the base beneath. The western 80 feet showed map cracking, the spiderweb fractures that form when a road's base has lost structural integrity, and the asphalt surface is flexing on a compromised foundation. He pressed his boot into the surface at the worst section and felt it flex. Not a surface problem, a base problem. The middle section had heaved, a 40-foot section where the road surface had risen 2 inches above original grade, on the north side of the center line, the heave running diagonally across the lane, in the pattern of frost heave in poorly drained subgrade. The ridge was already deflecting surface drainage sideways, instead of through the system. The drainage crossing had been the critical failure. At 220 feet from the county road entrance, a 24-inch corrugated metal pipe had been carrying seasonal runoff from the timber acreage since 1974. 49 years of service, 11 freeze-thaw cycles in one winter. The pipe had partially collapsed at its inlet end. The soil above the collapse had subsided. The road surface had dropped 4 inches across the full road width, collecting water, worsening with every vehicle crossing. Leonard had stood at the depression for a full minute. He had built and repaired roads for 35 years, and had assessed failures at every stage. This one was past the point where surface patching addressed the underlying problem. The culvert needed replacement. The base on both sides of the crossing needed excavation, recompaction, and new aggregate. If the repair was deferred through another season of heavy vehicle traffic, garbage trucks, fuel deliveries, contractor vehicles, the base failure would propagate outward from the crossing in both directions, and a $49,000 repair would become a $120,000 repair. He had gone back to the house and gotten his camera. He had photographed the road systematically, the full 340-foot crossing in overlapping images from both sides, the map cracking on the western section, the frost heave ridge in the middle, the drainage crossing depression from 4 angles, with a measuring tape showing the 4-inch depth, the collapsed culvert inlet visible where the surface had dropped away. 47 photographs, all dated by camera metadata, all documenting March 3, 2023. He had written a condition summary in his job log that evening. The damage categories, the locations measured from the county road entrance, the drainage crossing as the primary structural failure, his professional assessment that repair was necessary before summer traffic season. He had noted deferral risk, progressive base failure propagating from crossing in both directions, repair now or pay significantly more later. He had written the notice letter on March 8th, addressed to Sylvia Trent as HOA president and to the HOA management company. The letter described the damage, attached 5 representative photographs, referenced the 1989 maintenance agreement, and stated his intent to obtain contractor bids and initiate repair. He had sent it certified mail on March 9th and emailed a copy the same afternoon. Sylvia had received it March 11th. She had forwarded it to Dale Morrow, the HOA's property manager, 8 years on the job, who had driven the road himself in late February and had noted the drainage crossing depression in his inspection log with the notation, culvert failure, road subsidence, recommend repair before spring traffic season. Dale had emailed Sylvia. Leonard's assessment matches my February inspection. The drainage crossing is a legitimate structural failure. The repair is necessary. His notice is consistent with the maintenance agreement's process. Sylvia had replied, "Thank you, Dale. I'll handle the response." She had not responded to Leonard's notice letter. Leonard had obtained 3 contractor bids in the 3rd week of March, soliciting quotes from licensed paving and site work contractors whose work he knew from 35 years in the industry. The scope covered culvert replacement at the drainage crossing, full-depth base excavation and recompaction across the 60-foot section centered on the crossing, aggregate base installation, and asphalt surface repair across the full 180-foot affected length. The 3 bids had come in at $52,400, $49,500, and $61,800. He had selected the middle bid, Cascade Site Services, a licensed contractor with current bonding and insurance, whose principal he had worked alongside on 2 county road projects in the previous decade. The lowest bid had come from a contractor whose bonding had lapsed the previous year and whose license renewal was pending. Leonard had verified licensing and bonding for all three bidders before deciding. He had documented the verification in his job log. He had written a second letter to Sylvia on March 24th, informing her he had selected Cascade Site Services at $49,500 total, that work would begin the first week of April, and that the HOA's reimbursement share would be $24,750. He attached the three bid documents and the selected contractor's current license and bonding certificates, certified mail and email both. Sylvia had received the second letter on March 26th. She had forwarded it to Dale with one line, FYI. Dale had emailed back. The contractor selection looks solid. License and bonding are current. The bid is competitive for this scope. Should we send Leonard an acknowledgement? Sylvia had not replied. Cascade Site Services had mobilized April 4th. The crew at 7 a.m., the excavator and dump trucks on Leonard's storage yard by 7:30. Leonard had been on site for the full first day, the professional habit of a man who had managed construction projects for 35 years, and understood that the first day established the production rhythm for everything that followed. The culvert replacement had taken 2 days. The old 24-inch corrugated metal pipe came out in sections, its inlet's partial collapse confirming everything the surface depression had indicated. Leonard had specified a new 30-inch high-density polyethylene pipe at the improved diameter. The timber acreage's maturing canopy was producing increased runoff volumes, and the original undersized pipe had been a contributing factor in the subgrade's long-term deterioration. Proper bedding and backfill installed correctly. The base repair had taken 3 days. The excavation revealed subgrade that had been inadequately compacted in 1974 and had been marginally functional for 49 years before 11 freeze-thaw cycles exhausted its residual bearing capacity. Leonard had noted the original subgrade condition in his job log, with the specific satisfaction of a contractor whose pre-repair assessment had been exactly confirmed by what the excavation revealed. The surface work had taken 2 more days. Reclamation of the map-cracked western section, leveling of the frost heave ridge, new asphalt overlay across the full 180-foot repair length. The crew had finished April 12th. The surface rolled and cooling in the afternoon, the drainage crossing running clean through the new culvert, the road smooth and level across the repair section for the first time in what Leonard assessed had been several years of gradual deterioration. He had photographed the completed work, 43 photographs documenting the finished surface, the culvert inlet and outlet, the base layers visible and during construction excavation photographs, the drainage crossing before and after the elevation correction. He had compiled the documentation package over the following week. The before condition photographs from March 3rd, the 3 bid documents, the selected contractor's license and bonding certificates, the during construction base photographs, the after completion photographs, the contractor's invoice for $49,500, and a 1-page summary narrative describing the repair scope and confirming completion. He had sent the documentation package to Sylvia Trent on April 20th, physical package by certified mail and digital copy by email, the cover letter referencing the 1989 maintenance agreement, confirming the documentation requirement had been satisfied, and stating, "Enclosed, please find the complete documentation of the road repair completed April 12th, 2023, and an invoice for $24,750, representing the HOA's 50% share of the total repair cost of $49,500, pursuant to Section 3 of the maintenance agreement. Reimbursement is due within 45 days of receipt of this documentation, per Section 3B. Payment is due by June 6, 2023. Sylvia had received the package on April 22nd. She had called a board meeting for the following Tuesday. The board meeting had been April 25th, 5 members, the HOA Management Office, Dale Morrow present as property manager. Sylvia had presented the documentation package and the invoice. She had said, "Leonard Koss has submitted a repair invoice for $24,750, representing his claimed 50% share of a road repair he initiated without obtaining the board's prior written approval. The maintenance agreement requires documentation of repairs. It implies, by the documentation requirement, that repairs must be authorized before they are initiated. The board did not authorize this repair. The board did not approve this contractor or this scope. Leonard acted unilaterally and is now presenting us with an invoice for work we did not sanction. Dale had said, "The repair was necessary. I documented the drainage crossing failure in my February inspection. The culvert was failing. If Leonard hadn't repaired it this spring, it would have been twice the cost by fall." Sylvia had said, "That is not the question before the board. The question is whether we are obligated to reimburse a repair we did not authorize." Dale had said, "The maintenance agreement doesn't require authorization. It requires notice and documentation. Leonard sent notice in March and documentation in April. He followed the agreement exactly." Sylvia had said, "My reading of the agreement is that the documentation requirement implies a prior approval process. You don't document something after the fact unless the process contemplates approval before the fact." Dale had said, "Sylvia, that's not what the agreement says." She had said, "I understand your position. The board will vote." The vote had been 4-1. The one dissenting member was Phil Caruso, a resident who had read the maintenance agreement before the meeting and had told Sylvia privately that the prior approval requirement was not in the text. Sylvia had noted his dissent and called the vote. 4-1 to refuse payment on the grounds that Leonard had not obtained prior written approval. Leonard had received the written refusal on April 28th, a letter on HOA letterhead, signed by Sylvia, stating the board had voted to decline reimbursement because the repair had been initiated without prior board approval, and that future repairs requiring HOA cost sharing must be submitted for board authorization before work commenced. Leonard had read the letter at his kitchen table. He had set it down and gone to his contractor's files and pulled the 1989 maintenance agreement from the tab marked Hardin Cove Road. He had read it from the first paragraph to the last, all 4 pages. He had read Section 3 3 times. Prior approval did not appear in Section 3. It did not appear in any section. The word approval did not appear in the agreement at all. The agreement required notice before work. It required documentation after. It required reimbursement within 45 days. It said nothing about prior approval because Garrett's attorney in 1989 had written what the parties agreed to, and the parties had not agreed to a prior approval requirement. He set the agreement on the table beside the refusal letter and looked at both documents, the 4-page instrument that said what it said, and the 1-page letter claiming it said something it did not. He had been a contractor for 35 years. He had signed and administered hundreds of contracts. He knew exactly what a prior approval requirement looked like in a contract. It was specific language, deliberate words on a specific line, not an implication from a documentation provision, not a board president's interpretive theory, not a reading. It was text, explicit, unambiguous text. Those words did not exist on any of the 4 pages of the 1989 maintenance agreement. He wrote in his job log, April 28, 2023, HOA refusal received. Board claims prior approval required by agreement. Agreement reviewed. No prior approval requirement exists in the text. The word approval does not appear. Board has invented a contract term. Refusal is without contractual basis. Reimbursement deadline, June 6th. Call Vera Okafor Monday. He closed the job log and left the 2 documents on the table. Monday was 2 days away. June 6th was 39 days after that. Vera Okafor had been in real property and contract practice for 22 years, the kind of practice built on reading instruments carefully and telling clients what the instruments said rather than what the clients hoped they said. She had handled road maintenance agreements before, private road disputes, shared driveway cost-sharing arrangements, access easement maintenance obligations. The category of dispute was familiar. The specific facts of Leonard's situation she had assessed in the 20 minutes it took her to read the 1989 agreement the morning after he dropped a copy at her office. She had called him at 10:15 a.m. She had said, "I've read the agreement." He had said, "And." She had said, "There is no prior approval requirement." The word approval does not appear in the document. Section 3 requires written notice before work commences and documentation after completion. Section 3(b) requires reimbursement within 45 days of the documentation package. That is, the complete cost-sharing mechanism. There is nothing in the text that conditions reimbursement on prior board authorization. He had said, "That's what I read." She had said, "You read it correctly." Sylvia Trent's prior approval argument has no textual foundation. She has taken the documentation requirement, which is a post-completion obligation, not a pre-approval process, and has read into it an implication that the agreement requires pre-approval. That implication is not available. Contract interpretation does not allow a party to imply a material term that the drafters chose not to include. If Garrett and the HOA's board in 1989 had wanted a prior approval requirement, they would have written one. They wrote a notice requirement instead. Notice and approval are legally distinct obligations, and the distinction is not subtle. Leonard had said, "Can she make that argument in court?" Vera had said, "She can make it. It won't succeed." The agreement's language is clear, and a court interpreting a clear contract provision applies the plain meaning of the text. The plain meaning of Section 3 is notice before, documentation after, reimbursement within 45 days. There is no ambiguity that would allow a court to look beyond the text to imply a prior approval term. She had said, "I'm going to prepare a demand letter. The letter will set out the agreement's language, address the prior approval argument, and explain why it has no textual basis, confirm that your documentation package satisfied the agreement's requirements, and state that the 45-day reimbursement window is running. The letter will give the HOA a final opportunity to pay the invoice before you exercise your property rights over the road crossing." Leonard had said, "What does exercising my property rights mean in practical terms?" She had said, "The road crosses your parcel for 340 feet. The maintenance agreement governs cost sharing for the road's maintenance. It does not grant the HOA an access easement independent of the road maintenance relationship. It is a maintenance cost-sharing instrument, not an access instrument. Your parcel carries no recorded access easement in favor of the HOA or the Hardin Cove community in the county deed records. The HOA's community uses your road crossing by virtue of the road's historical presence on your land and the maintenance agreement's framework. If the HOA materially breaches the maintenance agreement by refusing to reimburse within the 45-day window, you have an argument that the breach suspends your obligations under the agreement. And your obligations under the agreement are the cost-sharing obligations that have kept the road relationship functional. The practical expression of that position is a gate. Leonard had been quiet for a moment. He had said, "A gate on my property, across the road." She had said, "On your property, at the point where the county road meets your western property line. The road is on your land for 340 feet. You own that land. The HOA's access through your land depends on the maintenance agreement's framework being honored by both parties. If the HOA refuses to honor its reimbursement obligation, the framework is broken. The gate is your notice that the framework matters." He had said, "When does the 45-day window close?" She had said, "You delivered the documentation package April 22nd. 45 days from April 22nd is June 6th. He had said, "Write the letter." Vera had sent the demand letter on May 5th, addressed to Sylvia Trent and to Frank Citro, the HOA's retained counsel, whose name had appeared on the board's refusal letter as the attorney consulted in connection with the refusal decision. The letter was 9 pages. The first 3 pages were the contract analysis. Section 3 of the 1989 Maintenance Agreement quoted in full, each provision identified and explained. The notice requirement. The initiating party shall provide written notice to the other party prior to commencing any repair or maintenance work. Leonard had provided written notice on March 9th, received by the HOA on March 11th. Notice satisfied. The documentation requirement. Upon completion of any repair or maintenance work, the initiating party shall provide the other party with documentation of the completed work, including contractor invoices, scope description, and photographic evidence of the repair. Leonard had provided the documentation package on April 20th, received by the HOA on April 22nd. Documentation satisfied. The reimbursement provision. The receiving party shall reimburse the initiating party for 50% of the documented repair cost within 45 days of receipt of the documentation package. Documentation received April 22nd. Reimbursement due June 6th. Reimbursement not made. The 4th and 5th pages address the prior approval argument. Vera had written with the precision of an attorney who had spent 22 years reading contracts and understood that the most effective response to a fabricated contract term was not rhetorical dismissal, but textual demonstration of its absence. She had written, The HOA's refusal letter asserts that the maintenance agreement requires prior board approval before the initiating party may commence repair work. The agreement contains no such requirement. The word approval does not appear in the agreement. The phrase prior approval does not appear. The concept of board authorization as a condition of the cost-sharing obligation does not appear in any section, subsection, or provision of the agreement. Section 3's documentation requirement is a post-completion obligation. It requires the initiating party to document what has been done, not to seek permission for what is proposed. The distinction between a documentation requirement and a prior approval requirement is fundamental and is not a matter of interpretation. Interpretation applies when text is ambiguous. This text is not ambiguous. It says what it says and does not say what the HOA claims it says. The 6th page addressed the implied term argument, the HOA's fallback position that the documentation requirement implied prior approval, even if it did not state it. Vera had written, "Contract law does not permit a court to imply a material term that the parties chose not to include when the contract's express terms address the subject matter." Section 3 addresses the repair and maintenance process completely. Notice before, documentation after, reimbursement within 45 days. The parties negotiated this framework in 1989 with the assistance of counsel. If they had intended a prior approval requirement, they would have included one. The absence of the requirement from a contract negotiated by attorneys is not an oversight to be corrected by implication. It is the parties' agreement. The 7th page was the factual record, Leonard's March 9th notice letter, the HOA's non-response, Dale Morrow's property inspection log notation from February, confirming the drainage crossing failure, Leonard's second letter on March 24th, with the contractor selection and bid documentation, the HOA's continued non-response, the repair completed April 12th, the documentation package delivered April 20th. The 8th page was the demand. The HOA's reimbursement obligation under Section 3B of the 1989 Maintenance Agreement is $24,750, due no later than June 6, 2023. Full payment by that date will resolve this matter. If payment is not received by June 6th, Mr. Koss will exercise his property rights with respect to the road crossing on his parcel, consistent with the HOA's material breach of the maintenance agreement's reimbursement obligation. The 9th page was the signature block and the exhibit list, 12 exhibits, the agreement, the notice letters, the documentation package components, and Dale Morrow's February inspection log notation, obtained through the HOA's public records process. Sylvia had received the letter on May 8th and had called Frank Citro before she finished reading it. Frank Citro had been practicing general law in the county for 18 years. Wills, real estate closings, some business contract work, occasional HOA governance matters. He was not a road maintenance agreement specialist, and he had told Sylvia that when she first called him in late April after receiving Leonard's documentation package, he had reviewed the board's refusal position and had drafted the refusal letter on Sylvia's instructions, noting in his file memo that the prior approval argument was based on the HOA president's interpretation of the agreement, rather than on explicit textual language. He had read Vera's demand letter on May. Leonard had repaired a failing culvert and the road base above it. Culvert replacement and base repair were maintenance and repair by any standard definition. The scope argument had no foundation. The contractor selection argument. The agreement did not specify a contractor selection process. Leonard had obtained 3 bids, verified licensing and bonding, and selected the middle bid from a contractor with a demonstrated track record. The contractor selection argument would require the court to imply a competitive bidding requirement that the agreement did not contain, the same implied term problem as the prior approval argument. The cost reasonableness argument, $49,500 for culvert replacement, base excavation and recompaction, aggregate installation, and asphalt overlay across 180 feet, was competitive with regional construction cost data. Frank had called 2 local contractors informally and had been told the price was reasonable for the scope. The cost argument had no foundation. He had called Sylvia on May 12th. He had said, "I've looked at scope, contractor selection, and cost reasonableness. None of them produces a viable defense to the reimbursement claim. The scope is covered by the agreement. The contractor selection was reasonable and documented, and the cost is within competitive range. The prior approval argument is the HOA's strongest position, and it is weak. Sylvia had said, "What do you recommend?" He had said, "Pay the invoice. $24,750 resolves the matter before the June 6th deadline and avoids whatever Leonard means by exercising his property rights over the road crossing. I don't know exactly what that means, but I know the road crosses his parcel for 340 feet, and I know the agreement doesn't contain an access easement provision." Sylvia had said, "The board voted to refuse payment." He had said, "The board can vote again." She had said, "I'll call a board meeting." The board meeting had been May 16th. The same 5 members, Frank Citro on the phone, Dale Morrow present. Sylvia had presented Frank's assessment. The prior approval argument was weak. The alternative arguments were weaker. Frank recommended paying the invoice. Phil Caruso had said, "I said this in April. The prior approval requirement isn't in the agreement. I read the agreement before the first vote and told Sylvia that. We should have paid in April." Sylvia had said, "The board will hear from Frank directly." Frank had said from the speakerphone, "The maintenance agreement's text does not support the prior approval argument." Vera Okafor's demand letter analysis is accurate on the contract language. "I cannot identify a viable defense to the reimbursement claim that would survive a motion in court. My recommendation is to pay the invoice before the June 6th deadline." A board member named Carol Finch had said, "What happens if we don't pay by June 6th? Frank had said, "The demand letter says Leonard will exercise his property rights over the road crossing. The road crosses his parcel for 340 feet. The maintenance agreement is a cost-sharing instrument. It does not contain an access easement clause, granting the HOA a right of access across Leonard's parcel, independent of the maintenance relationship. If Leonard installs a gate on his property at the road entrance, the HOA's legal basis to compel him to open it is not straightforward." Carol had said, "He can actually lock us out." Frank had said, "It's his property. The road is on his land. The legal question of whether he can gate it is not simple, but it is not simple in his favor, not ours." Sylvia had said, "The board voted in April on a principle. The principle was that repairs require board approval. We cannot abandon that principle because an attorney wrote a demand letter." Dale had said, "Sylvia, the principle isn't in the agreement." She had said, "That's a matter of interpretation." Dale had said, "It's not a matter of interpretation. Frank just told the board the argument is weak. Phil said it in April." Vera Okafor's letter said it for 9 pages. The word approval is not in the agreement. Sylvia had looked at Dale and had said, "Your input has been noted." She had called the vote. 4-1 again, Phil Caruso dissenting again, the same 4 members voting to maintain the refusal on the same grounds that Frank had just told them were legally weak. The board had heard the legal assessment and had voted to ignore it. Frank had said from the speakerphone, after the vote, "I wanted in the minutes that I recommended paying the invoice, and the board voted against my recommendation." Sylvia had said, "So noted." The days between May 16th and June 6th had passed in the specific quiet of a situation that had been decided and was waiting for its consequences to arrive. Leonard had checked the mail each day without expectation. He had not expected a check after the second board vote, any more than he had expected one after the first. He had expected what the calendar showed, a 45-day window that the HOA had decided to let close. He had used the 3 weeks to prepare. He had purchased a commercial-grade steel gate, a 14-foot heavy-duty farm gate, the kind rated for repeated vehicle contact, with a heavy drop bar and a commercial padlock hasp designed for a case-hardened shackle padlock. He had set the gate posts in concrete at the western edge of his parcel. On a Saturday morning in late May, the posts positioned 3 feet inside his property line, the gate spanning the full road width with a foot of clearance on each side. He had not hung the gate. The posts stood in their concrete, curing, ready. He had written in his job log on May 28th, "Gate post set, western approach, road crossing entrance, concrete curing, 7 days, gate, ready to hang, padlock, purchased, June 6th, 9 days. He had written Vera a brief email. "Posts are in. I'll hang the gate the morning of June 6th if no payment has been received. Let me know if anything changes on your end." Vera had replied, "Nothing has changed. The board voted 4-1 on May 16th to maintain the refusal after Frank Citro told them the prior approval argument was weak. "I'll be available June 6th if you need me." June 5th had been a Sunday. Leonard had checked the mail, nothing, and had looked at the gate post standing at the road entrance in the late afternoon light, the concrete fully cured, the hardware ready. He had thought about the 58 households on the other side of the gate he was about to hang, families who had no dispute with him, who had watched the road get repaired, who were about to find out what their board's 4-1 vote had cost them. He had not felt satisfaction about that. He had felt the specific absence of alternatives that a man feels when he has done everything correctly, given every reasonable notice, waited every required day, and arrived at the only remaining option. He had written in his job log on June 5th, June 5th, 2023, no payment received. Documentation delivered April 22nd. 45-day window closes June 6th. Board voted twice to refuse payment. Prior approval requirement does not exist in the agreement. I gave notice. I documented the repair. I submitted the invoice. I sent a demand letter. I waited 45 days. Tomorrow, I hang the gate. He had closed the log and gone inside. The gate posts stood in their concrete at the road entrance, casting their shadows in the evening light across the road his grandfather's predecessor had built in 1974, and that he had repaired in April, and that the Hardin Cove HOA had decided, twice, was not worth $24,750 to maintain. June 6th was tomorrow. Leonard had been at the road entrance at 6 a.m. on June 6th, the morning cool and overcast, the county road empty in both directions, the gate posts standing in their cured concrete, where he had set them 10 days earlier. He had brought the gate in the bed of his truck, the 14-foot commercial steel gate he had purchased in late May, the drop bar hardware, the padlock hasp, the case-hardened shackle padlock in its packaging, and 2 aluminum signs he had made at the print shop in town, 12 by 18 inches, black text on white, reading, "Private property, Koss parcel, road closed, contact Leonard Koss," with his phone number below. He had also brought his contractor's camera and his job log. He had hung the gate in 40 minutes, the strap hinges bolted to the left-hand post, the gate frame seated on the hinges, the drop bar receiver welded to the right-hand post, accepting the drop bar cleanly, the alignment checked with a level. He had swung the gate through its arc twice to confirm the movement was free and the drop bar seated fully in the receiver. He had screwed the signs to the posts at eye level, one on each gate post, the text readable from a vehicle approaching from the county road or from the community side. He had taken the padlock from its packaging, threaded it through the drop bar's eye and the receiver post's hasp, and clicked it shut. He had stepped back and looked at the gate, the steel frame spanning the road width, the drop bar seated, the padlock engaged, the signs on both posts. The road beyond the gate ran east toward the Hardin Cove Community Gate, 340 feet away, the surface of the April repair visible in the overcast morning light, smooth and level across the full repair section. He had photographed the gate from 3 angles, the approach from the county road, the gate face, the signage on both posts, and had written in his job log at 6:47 a.m., June 6th, 2023, day 46, gate installed and locked, western entrance, road crossing, Koss parcel, documentation delivered April 22nd, 45-day reimbursement window closed June 5th, no payment received, gate, locked, padlock, engaged, road, closed pending payment of invoice, April 2023, $24,750. He had driven back to the house, made coffee, and waited. The first call had come at 7:22 a.m. Not from Sylvia, from a resident named Gary Pelham, a retired engineer who lived in the 3rd house past the community gate, and who left for his morning walk at 7:15 every day, and had reached the locked gate at 7:19, and had read the sign, and had taken Leonard's number from it. Gary had said, "Mr. Koss, Gary Pelham, 14 Hardin Cove Drive. Your gate is locked across the road." Leonard had said, "Yes." Gary had said, "I can't get out." Leonard had said, "That's right. The gate is locked because the HOA has not paid a repair invoice that was due yesterday under the 1989 maintenance agreement. When they pay the invoice, the gate opens." Gary had said, "What invoice?" Leonard had said, "The road repair from April, the drainage crossing, the culvert replacement and the base work, $49,500 total. The HOA's share is $24,750. I submitted the invoice on April 20th. It was due June 5th. They didn't pay." Gary had been quiet for a moment. He had said, "The board voted not to pay?" Leonard had said, "Twice. Once in April and once in May. Both times 4-1. Gary had said, "And now the gate is locked." Leonard had said, "Yes." Gary had said, "Who do I call?" Leonard had said, "The board president is Sylvia Trent. Her number is on the HOA's website. The gate opens when the invoice is paid." He had ended the call and written in his log, 7:22 a.m., Gary Pelham, 14 Hardin Cove Drive. Explained situation, referred to board. The calls had come in intervals after that, a resident every 10 to 15 minutes through the 7 and 8 o'clock hours, the pattern of a neighborhood waking up and discovering that the road they used every day was closed behind a locked gate with a phone number on the sign. Leonard had answered every call. He had given every caller the same information: the repair, the invoice, the 45-day window, the board's 2 refusal votes, the gate. He had been patient and factual with each caller. He had referred each one to Sylvia Trent. He had not expressed frustration or satisfaction. He had stated the situation and the condition for resolution. The invoice, $24,750. Payment releases the gate. By 8:30, he had taken 11 calls. By 9 a.m., he had taken 16. Sylvia had called at 8:54. She had said, "Leonard, this is Sylvia Trent. I need you to open the gate." He had said, "Good morning, Sylvia. The gate opens when the invoice is paid. $24,750. Account information is on the invoice you received in April." She had said, "You cannot close a road that 58 families depend on for access to their homes." He had said, "It's my road. It crosses my property. The maintenance agreement required reimbursement within 45 days. The 45 days ended yesterday. The gate is the consequence of the board's decision not to pay." She had said, "The board's position is that the repair required prior approval. That position has not changed." He had said, "The agreement doesn't require prior approval." Vera Okafor explained that in 9 pages. "Your own attorney told you the argument was weak. The board voted to maintain the refusal anyway. The gate is what follows from that vote." She had said, "I'm going to have Frank Citro file an emergency injunction to compel you to open the gate." He had said, "That's Sylvia's right. The gate stays locked until the invoice is paid or a court orders otherwise. I'd suggest calling Vera Okafor first, so you understand what the injunction requires before you file it." She had said, "I know what an injunction requires." He had said, "Then you know it requires a likelihood of success on the merits. The merits are the maintenance agreement. I'll talk to you when the invoice is paid." He had ended the call and written in his log, 8:54 a.m., Sylvia Trent, threatened injunction. Advised payment resolves the matter. Gate stays locked. Sylvia had called Frank Citro at 9:03. She had said, "The gate is up. Leonard locked the road this morning. I need you to file an emergency injunction." Frank had said, "Tell me the situation." She had described it, the gate, the sign, Leonard's statement that the gate would stay locked until the invoice was paid. Frank had been quiet for a moment. He had said, "An emergency injunction to compel him to open the gate requires 3 things: a likelihood of success on the merits, irreparable harm, and the balance of equities favoring the injunction." The irreparable harm element is arguable. 58 households locked out of their homes is a strong irreparable harm showing. The balance of equities is arguable. The likelihood of success on the merits is the problem. Sylvia had said, "Explain the problem." He had said, "Likelihood of success on the merits means the court looks at the underlying dispute and assesses whether the HOA is likely to win. The underlying dispute is the maintenance agreement. The HOA's position is the prior approval argument. I told the board on May 16th that the prior approval argument is weak. The court evaluating an emergency injunction is going to read the same agreement I read. The word approval is not in it. A court that reads the agreement and does not find the word approval is going to assess the HOA's likelihood of success as low. Sylvia had said, "So you're telling me we can't get an injunction?" He had said, "I'm telling you the injunction application is difficult because the prior approval argument doesn't hold up when a judge reads the agreement. The injunction's purpose is to maintain the status quo while the underlying dispute is resolved. The court may be sympathetic to 58 locked-out households, but sympathy doesn't substitute for likelihood of success on the merits." She had said, "File it anyway. We need to show the residents we're acting." He had said, "Sylvia, I need to be direct with you. Filing an injunction application that I assess as unlikely to succeed is not the most effective response to this situation. The most effective response is paying the invoice. $24,750 resolves this immediately and reopens the road this morning." She had said, "The board voted to refuse payment. I am not going to reverse a board vote without a board meeting." He had said, "Then call a board meeting today." She had said, "I need the injunction filed first." "File it." Frank had said, "I'll file it this afternoon. I want the conversation about board meeting timing to continue in parallel." Sylvia had not responded to that and had ended the call. The emergency board meeting had been called for 2 p.m., Sylvia sending the notice to all 5 members at 10 a.m. The meeting format an emergency session under the HOA bylaws urgent business provision. By the time the notice went out, the HOA's community forum, the online platform where Hardin Cove residents posted neighborhood business, had been running for 3 hours, with posts from residents who had read the sign on Leonard's gate, called his number, learned about the invoice, and come home to ask why their board had refused a $24,750 repair bill and produced a lockout. The posts had been numerous and pointed. A woman named Sandra Olson at 22 Hardin Cove Drive had written, "Can someone explain why the board voted twice to refuse to pay a road repair invoice? The sign on the gate has Leonard Koss's number. I called him. He explained the situation clearly. The maintenance agreement required reimbursement in 45 days. The board voted not to pay. We are now locked in. What is the board's explanation?" A man named Robert Finch, no relation to board member Carol Finch, had written, "I have a medical appointment at 10 a.m. tomorrow. I need to know if this gate will be open by then." A retired attorney named Marcus Webb at 31 Hardin Cove Drive had written, "I've practiced contract law for 30 years. I pulled the 1989 maintenance agreement from the county deed records this morning. There is no prior approval requirement in the agreement. The board refused payment on a legal theory that does not exist in the text. I'd like the board to explain its legal basis for the refusal at the emergency meeting." Dale Morrow had seen the forum posts from his office at 10:30 a.m. and had driven to the gate to assess the situation directly. He had looked at the locked gate, the signs on the posts, the road beyond. He had stood at the gate for 2 minutes and had driven back to the office and had called Sylvia. He had said, "I've been at the gate. It's locked. Residents are reading the sign and calling Leonard's number, and Leonard is telling them about the invoice. The forum has been running since this morning. Marcus Webb has already posted that he pulled the agreement from the county records, and there's no prior approval requirement in it." Sylvia had said, "I've seen the forum posts." Dale had said, "Sylvia, this is going to get worse before the 2 o'clock meeting. People can't get to work. A resident has a medical appointment tomorrow. The situation the board created by refusing a $24,750 invoice is now visible to every resident, and several of them are reading the agreement themselves and reaching the same conclusion Leonard did." Sylvia had said, "We're handling it through the injunction and the board meeting." Dale had said, "The injunction requires likelihood of success on the merits." Frank told the board on May 16th the prior approval argument was weak. A judge reading the agreement is going to reach the same conclusion Marcus Webb reached this morning. The injunction isn't going to open the gate by tomorrow. Paying the invoice will open the gate today. Sylvia had said, "That decision is the board's, not yours." Dale had said, "Then I'll make my recommendation to the board at 2 o'clock. The board meeting had convened at 2 p.m. All 5 members, Frank Citro on the phone, Dale Morrow present, the community forum visible on the laptop Sylvia had set on the conference table, showing the mounting resident posts. Sylvia had opened the meeting. She had said, Leonard Koss installed a gate across the road entrance this morning and has locked 58 households out of the community. Frank Citro has filed an emergency injunction motion to compel him to open the gate. The board is meeting to assess next steps. Phil Caruso had said, "The next step is paying the invoice. I said that in April, and I said it in May, and I'm saying it again now. The gate is what voting twice against Frank's advice produces." Sylvia had said, "The board's position has been consistent. The repair required prior approval. That position is the basis for the refusal." Marcus Webb had called into the meeting. Sylvia had not invited him, but the bylaws allowed resident attendance at board meetings, and he had asked to speak during the public comment period. She had not planned to include. She had allowed it because refusing a retired contract attorney public comment in an emergency board meeting called over a contract dispute was not a defensible position. Marcus had said, "I pulled the 1989 maintenance agreement from the county deed records this morning. I have practiced contract law for 30 years. There is no prior approval requirement in the agreement. The word approval does not appear. The board has refused a legitimate reimbursement claim on a legal theory with no textual foundation, locked out 58 households, and is now seeking an injunction that requires likelihood of success on the merits of that same legal theory. I'd like to ask Frank Citro directly, what is the likelihood of success on the merits of the prior approval argument?" Frank had said from the speakerphone, "I assessed it as weak in my recommendation to the board on May 16th. That assessment has not changed." Marcus had said, "Thank you." Sylvia had said, "Marcus, we appreciate your input. The board will deliberate." Dale had raised his hand. He had said, "I want to state for the record what I have been telling the board since April. The road repair was necessary. I documented the drainage crossing failure in my February inspection log. I noted culvert failure and recommended repair before the spring traffic season. Leonard's notice letter in March confirmed the same failure I had already identified. The documentation package he submitted in April was complete and professionally prepared. The contractor selection was reasonable and the cost was competitive. The prior approval requirement does not exist in the agreement. The board has refused a legitimate claim twice, against the advice of its own attorney, and has produced a situation in which 58 households are locked out of their homes on a Tuesday morning. I am recommending that the board pay the invoice today." Sylvia had looked at Dale and had said, "Your input has been noted, Dale. Your opinion on the board's legal positions was not requested." Dale had said, "My opinion on the road's physical condition was documented in my inspection log in February. My opinion on the maintenance agreement's language is the same opinion Frank Citro gave the board on May 16th. I'm not offering a novel position. I'm repeating what the board's own attorney said 2 weeks ago." Sylvia had said, "The board will vote on whether to authorize payment of the invoice." Carol Finch had said, "Before we vote, Frank, if the injunction fails, what is our position?" Frank had said, "If the court denies the injunction, the gate stays locked until the underlying dispute is resolved. Resolution means either payment of the invoice or a court judgment on the reimbursement claim. A judgment proceeding will take months. The gate will be locked during that period unless Leonard agrees to open it pending resolution, which he has given no indication of doing." Carol had said, "Months." Frank had said, "At minimum." The board had been quiet for a moment. Sylvia had said, "The board will vote on payment of invoice 2023-04 in the amount of $24,750 to Leonard Koss." Phil Caruso had voted yes immediately. Carol Finch had looked at Sylvia and had said yes. The third member, a man named Tom Graves, who had voted against payment in both April and May, had looked at the laptop showing the community forum and had said yes. The fourth member, Janet Osei, who had also voted against payment twice, had said yes. Sylvia had looked at the 4 yes votes around the table. She had said, "I vote no. The motion carries 4-1. The invoice will be paid." She had said it with the flatness of a person who had just watched a position she had held for 6 weeks collapse under the weight of a locked gate, and a retired contract attorney who had pulled the agreement from the county deed records and spent 30 seconds finding the thing that wasn't there. Frank had said from the speakerphone, "I'll withdraw the injunction motion before end of business." Dale had already taken out his phone. Frank had filed the emergency injunction motion at 4:15 p.m. on June 6th. The same afternoon the gate went up, the filing time to reach the court's emergency docket before the clerk's office closed at 5. The motion ran to 14 pages and had been drafted in the 4 hours between Sylvia's 9 a.m. call and the filing deadline, the speed showing in the brief's structure, competent but compressed, the arguments present but not developed to the depth Frank would have given them with a week's preparation time. The motion's theory was straightforward. 58 households were locked out of their homes by a gate on a private road they had used for access for 49 years. The lockout constituted irreparable harm, and the court's equitable authority extended to emergency injunctive relief, compelling the gate's opening while the underlying contractual dispute was resolved through the normal litigation process. Frank had framed the irreparable harm section first, and had spent 5 of the 14 pages there. The strongest part of the motion, the factual predicate that he believed would move a judge most immediately. 58 families, medical appointments, work commutes, school buses, emergency vehicle access. The harm was real, immediate, and not compensable by money damages after the fact, because the lockout was happening now, and every day it continued produced new harm to people who had no role in the contractual dispute between Leonard and the board. The likelihood of success section had been the motion's difficult terrain. Frank had spent 4 pages on it and had not been able to make it stronger than what the agreement's text allowed, which was not strong. He had argued the prior approval theory in the most favorable framing available, not as an explicit textual requirement, but as a reasonable implied term arising from the agreement's documentation structure, and had cited 2 contract law cases involving implied terms in maintenance agreements. Neither case was directly on point. He had noted them in the brief and had moved on, the citation of weak authority being preferable to the citation of no authority. He had filed the motion, emailed a copy to Vera Okafor's office, and had sat at his desk for a moment after hitting send. He had been practicing law for 18 years. He had filed motions he believed in, and motions he filed because the client instructed him to file them. This one was the second category, and he had known it since Sylvia said file it anyway at 9:03 a.m. Vera had read the motion that evening and had called Leonard at 7 p.m. She had said, Frank filed the emergency injunction, 14 pages. The irreparable harm section is strong. 58 households locked out is a compelling factual showing. The likelihood of success section is the prior approval argument dressed in implied term language. 2 cases cited, neither on point. Leonard had said, when is the hearing? She had said, emergency injunctions in this court get a hearing within 72 hours of filing. The clerk will set it for Thursday or Friday. I'll have your response brief ready by Wednesday morning. Leonard had said, what do I need to show? She had said, you need to defeat the likelihood of success element. If the court finds the prior approval argument legally insufficient, which it should, because the argument has no textual basis, the injunction fails regardless of how strong the irreparable harm showing is. You cannot get an injunction to enforce a right you are unlikely to have. The HOA's claimed right is the right to condition reimbursement on prior approval. That right is not in the agreement. If the court reads the agreement and reaches the same conclusion every attorney who has read it has reached, the injunction is denied. She had said, I also want to address the access easement issue directly in your response. The motion implies that the HOA has a right of access across your parcel that is independent of the maintenance agreement, that the road's 49-year history of community use creates some sort of implied easement that Leonard is now violating. I want to foreclose that argument before Frank develops it further. Leonard had said, is that argument available to him? She had said, implied easement from prior use is a recognized doctrine. An implied easement can arise from a property's historical use pattern under certain conditions. The conditions require the prior use to have been apparent, continuous, and reasonably necessary for the enjoyment of the dominant estate. The HOA will argue that 49 years of community road use establishes an implied easement that Leonard cannot gate. I will argue that the 1989 maintenance agreement's existence as a recorded instrument forecloses the implied easement theory. When parties have reduced their road access arrangement to a written recorded instrument, the instrument governs, and there is no room for an implied easement alongside it. Leonard had said, The agreement covers the road, and the agreement doesn't have an access easement provision. She had said, exactly. The parties in 1989 chose to address the road relationship in a written instrument. They chose what to include and what to leave out. They included cost sharing, and they did not include an access easement. A court should not imply what the parties deliberately omitted. She had said, I'll have the response brief ready Wednesday morning. The hearing will likely be Friday. Vera's response brief had been filed Wednesday at 9 a.m., 21 pages, the length reflecting the preparation time she had used that Frank had not had. The brief's first section addressed the likelihood of success element directly and at length. She had quoted Section 3 of the maintenance agreement in full, bolded the operative provisions, and had written, the agreement requires written notice before work commences, documentation after completion, and reimbursement within 45 days of the documentation package. These are the agreement's complete cost-sharing mechanics. The HOA asserts that the documentation requirement implies a prior approval process. This assertion is legally unavailable for 3 reasons. First, the agreement's text is clear and unambiguous, leaving no room for implied terms. Second, contract law does not permit the implication of a material term that the drafting parties chose not to include. And third, the HOA's own retained counsel advised the board on May 16th that the prior approval argument was weak. That assessment is now in the board meeting minutes and constitutes the HOA's own attorney's contemporaneous evaluation of the argument's legal merit. The citation of Frank's own assessment from the board meeting minutes had been the response brief's most pointed moment. The HOA's attorney's statement that the argument was weak now appearing in the opposing brief as an admission. Vera had obtained the minutes through the HOA's public records process on Tuesday afternoon, 24 hours after the gate went up. The production of public records being something the HOA's management company was obligated to provide within a reasonable time on request. The second section addressed the implied easement argument she had anticipated Frank developing. She had written, the HOA's motion implies a right of access across Leonard Koss's parcel, arising from 49 years of community road use. To the extent the HOA intends to assert an implied easement theory, that theory is foreclosed by the 1989 maintenance agreement. When parties reduce their property access arrangement to a written recorded instrument, the instrument governs the relationship and displaces any implied rights that might otherwise arise from prior use. The 1989 agreement addressed the road relationship comprehensively. It allocated maintenance costs, established the repair process, and set the reimbursement timeline. It did not include an access easement provision. The omission was not inadvertent. It was the product of negotiation between parties represented by counsel. A court should not imply what the parties deliberately omitted from a negotiated written instrument. The third section was the material breach analysis. The argument that the HOA's refusal to reimburse within the 45-day window constituted a material breach of the maintenance agreement that suspended Leonard's cost-sharing obligations and, with them, the practical framework that had kept the road relationship functional. Vera had written, a material breach by one party to a contract suspends the other party's performance obligations under the agreement. The HOA's obligation under Section 3B was to reimburse Leonard Koss within 45 days of receiving the documentation package. The documentation package was received April 22nd. The 45-day window closed June 5th. No payment was made. The HOA's failure to reimburse is a material breach of the agreement's central cost-sharing obligation. Leonard Koss's gate is not a wrongful act. It is the practical consequence of the HOA's decision to breach its reimbursement obligation. The court should not use its equitable authority to insulate the HOA from the consequences of its own material breach. The brief's final section addressed the balance of equities, acknowledging the 58 households' difficult position and redirecting it. The 58 Hardin Cove households are in their current situation because the HOA's board voted twice to refuse a legitimate reimbursement claim against the advice of its own retained counsel. The harm flowing from the gate falls on residents who had no role in the board's decision. The equitable remedy for that harm is not an injunction requiring Leonard Koss to bear the cost of the HOA's breach. It is payment of the $24,750 invoice that the HOA has owed since June 5th. The gate opens the moment the invoice is paid. The balance of equities does not favor an injunction that rewards the breaching party with continued access at the non-breaching party's expense. The hearing had been set for Friday morning. Judge Carol Menton, County District Court, Courtroom 1, 9 a.m. Judge Menton had been on the civil docket for 6 years. Her background in commercial contract disputes, her reputation for reading primary documents at the hearing, rather than relying exclusively on the briefs. She had read both briefs before Friday, but she had also brought the 1989 maintenance agreement to the bench, the county recorder's certified copy, pulled from the deed records by her clerk on Thursday afternoon at her request. Frank and Vera had taken their positions at counsel table at 8:55. Leonard had sat behind Vera at the gallery rail. Sylvia had sat behind Frank. Judge Menton had opened the hearing at 9:02. She had said, "I've read both briefs. I've also read the 1989 maintenance agreement, which I pulled from the deed records yesterday. I want to address the likelihood of success element first, because it is the element that controls the injunction's availability, regardless of the irreparable harm showing." She had looked at Frank. She had said, "Mr. Citro, the HOA's position is that the maintenance agreement requires prior board approval before the initiating party can commence a repair. I've read the agreement. I want you to point me to the provision that establishes that requirement." Frank had stood. He had said, "Your Honor, the HOA's position is that the documentation requirement in Section 3 implies a prior approval process, that the requirement to document repairs after completion presupposes an authorization process before commencement." Judge Menton had said, "I understand the implication argument. I'm asking you to point me to the provision. Is there language in Section 3 or anywhere else in the agreement that explicitly requires prior board approval?" Frank had looked at his copy of the agreement. He had turned to Section 3 and had read it. He had looked at Section 1, the definitions section. He had looked at Section 2, the general maintenance obligations section. He had turned back to Section 3. He had said, "The explicit language requiring prior approval is not in the agreement, Your Honor. The HOA's position relies on the implied term arising from the documentation structure." Judge Menton had said, "The agreement was negotiated by parties represented by counsel in 1989. Is that correct?" Frank had said, "Yes, Your Honor." She had said, "And the agreement contains a notice requirement, written notice before work commences, but does not contain an approval requirement. The drafting parties knew how to write a pre-commencement requirement because they wrote one, the notice requirement. They chose to write a notice requirement and not an approval requirement. Is there a basis for implying an approval requirement alongside an express notice requirement when the same provision contains both pre-commencement and post-completion obligations, and the drafters included only one pre-commencement obligation?" Frank had been quiet for 4 seconds. He had said, "The HOA's position is that the documentation requirement's purpose is best served by reading it in conjunction with a prior approval process." Judge Menton had said, "That is a policy argument about what the agreement should have said, not a legal argument about what it does say. The implied term doctrine requires that the implied term be necessary to give business efficacy to the agreement, that the agreement cannot function without it. Can the 1989 maintenance agreement function without a prior approval requirement?" Frank had said, "It can function without it, Your Honor, but the HOA's position is that," Judge Menton had said, "if the agreement can function without the implied term is not necessary to give the agreement business efficacy, and the doctrine does not apply. I understand the HOA's position. The position does not have a sufficient legal foundation to establish likelihood of success on the merits. Let me hear from Ms. Okafor." Vera had taken 8 minutes. She had addressed the implied term doctrine, the material breach analysis, and the balance of equities in sequence, the arguments developed in her brief, delivered in condensed oral form. She had ended with the board meeting minutes. Frank's May 16th statement that the prior approval argument was weak, now in the record as the HOA's own counsel's contemporaneous assessment. Judge Menton had made a note and had said, "I'm going to rule from the bench." She had looked at both counsel and had said, "The emergency injunction motion is denied. The likelihood of success element is not satisfied. The 1989 maintenance agreement does not contain a prior approval requirement. The implied term doctrine does not apply because the agreement functions without the implied term, and because the drafting parties included an express pre-commencement obligation, the notice requirement, and did not include an approval requirement, indicating a deliberate choice rather than an oversight. The HOA's likelihood of success on the merits of the prior approval argument is low. Without likelihood of success, the injunction is unavailable, regardless of the strength of the irreparable harm showing. She had paused and had looked at both tables. She had said, "I want to observe for the record that the maintenance agreement's reimbursement provision is clear. The documentation was submitted on April 20th. The 45-day window closed June 5th, and no payment was made. The gate on Leonard Koss's property is the practical consequence of the HOA's decision not to reimburse within the contractual window. The court's equitable authority does not extend to shielding a party from the consequences of its own breach. The motion is denied. The gate remains." She had closed the folder and had looked at Frank. She had said, "Mr. Citro, I would encourage you to advise your client that the path to reopening the road is payment of the invoice." Frank had said, "Yes, Your Honor." The gate had been locked for 5 days when the rain started. It had begun Thursday evening, a slow front moving in from the northwest. The rain steady through Thursday night and into Friday, the day of the injunction hearing. By the time Judge Menton denied the motion at 9:30 Friday morning, the county had received 2 inches, and the forecast showed 2 more through the weekend. The 2-track farm path had appeared on day 2 of the lockout, an informal arrangement between a Hardin Cove resident named Peter Connolly and the owner of the adjacent agricultural parcel to the south, a farmer named Bob Dietz, who had known Peter for 20 years and had told him on day 1 that residents could use the field access track along his southern fence line to reach the county road, a rough, unpaved path that ran through Dietz's hayfield and exited at a farm gate on the county road a quarter-mile south of Leonard's locked gate. In dry conditions, the path was passable, narrow, ungraded, the surface a mix of gravel and packed clay that held up under normal farm vehicle traffic. Bob Dietz had not designed it for passenger cars and had told Peter as much, but he had left the gate unlocked and had said nothing more about it. In dry conditions, residents had been using it in single file, the cars moving slowly through the hayfield in a line, the path holding under the volume. The rain had changed the path's character by Thursday evening, the clay surface beginning to soften, the tire tracks from 3 days of passenger car traffic cutting through the surface into the subgrade, the drainage from the adjacent field sheeting across the path's low sections. By Friday morning, when the injunction hearing was proceeding in Courtroom 1, 3 inches of the path's worst section had become a soft clay slick that was passable in a high-clearance vehicle with careful speed management, and was a trap for anything lower or faster. A sedan belonging to a resident named Carol Vance had gotten stuck in the path's low section at 7:15 Friday morning. Before the hearing, before the ruling, the car's rear wheels spinning in the softened clay, the vehicle settling sideways off the path's edge into the drainage channel running along the field's southern margin. Carol had called her husband. Her husband had called Peter Connolly. Peter had called Bob Dietz. Bob had come out with his tractor and had pulled the car free in 20 minutes, the tractor's front loader bucket used as a push point, the car coming out of the channel with clay packed into its undercarriage and a bent exhaust bracket. By Friday afternoon, the injunction denied, the rain continuing, the path deteriorating through the day's traffic. 2 more vehicles had gotten stuck in the same section. Bob Dietz had pulled both of them out with the tractor. After the second recovery, he had called Peter and had said, "I can't keep pulling cars out of my drainage channel. If it keeps raining through the weekend, the path is going to be impassable by Saturday morning." Peter had called Sylvia. He had told her what Bob had said. He had told her about Carol Vance's car. He had told her the injunction had been denied. He had said, "Sylvia, the path is going to close by Saturday. When the path closes, there is no way in or out. Not a slow way, no way." Sylvia had said, "I'm aware of the situation." Peter had said, "Are you aware that a resident is going to have no access to their home by Saturday morning if the rain continues?" She had said, "The board is convening this afternoon." He had said, "This afternoon needs to produce a check." She had ended the call. The rain was still falling. The path was still softening. The gate was still locked. The invoice was $24,750 and had been due on June 5th, and the board had voted 4-1 to refuse it in April and 4-1 to refuse it again in May, and the court had read the agreement on Friday morning and had reached the same conclusion every attorney who had read it had reached. The gate was on Leonard's property. The road was on Leonard's land. The agreement required reimbursement in 45 days. Day 5 of the lockout was a Friday afternoon in June, with 2 inches of rain forecast through the weekend, and a farm path that Bob Dietz had said would be impassable by Saturday morning. The invoice was $24,750. It had been $24,750 since April 20th. The rain had not stopped Saturday. Bob Dietz had called Peter Connolly at 7 a.m. The path was gone. Not difficult, not marginal, gone. The low section that had taken Carol Vance's car on Friday morning had flooded overnight, the drainage channel overtopping its bank across a 20-foot stretch of the path. The surface beneath the water, a soft clay that would take a farm vehicle's weight and nothing lighter. Bob had walked it at first light in his boots and had sunk 4 inches at the worst point. He had said, "I'm sorry, Peter. I can't let people drive through this. Someone's going to go into the ditch and I won't be able to get them out until the ground dries." Peter had said, "I understand. I'll let people know." He had posted to the community forum at 7:15. Bob Dietz has had to close the farm path. It flooded overnight and is not passable. There is currently no vehicle access in or out of Hardin Cove. Foot access is possible via the path on foot only. This situation is entirely the result of the board's refusal to pay Leonard Koss's road repair invoice. The board has the ability to resolve this today by paying the invoice. The gate opens when the check clears. The forum had been active since day 1 of the lockout, but Saturday morning's thread had a different quality. The posts of people who had moved from frustrated to confined, the specific register of a neighborhood that had woken up with no way out and was now documenting its situation for a record it understood would matter later. Sandra Olson had posted at 7:40. "My husband takes dialysis 3 times a week. His transport van cannot reach the house. I have called the transport company, and they cannot navigate the farm path. I need to know what the board is doing today to resolve this." Robert Finch had posted at 8:05. "Medical supply delivery scheduled for today. Glucose monitoring equipment. The delivery service says they cannot access the property. I have called the HOA management line and left a message. I have not received a response." Marcus Webb had posted at 8:20. "For anyone keeping track, the board has now refused payment twice, lost an emergency injunction, and produced a situation in which a resident with a medical need cannot receive a delivery and another resident cannot reach dialysis. The invoice is $24,750. The board has been advised by its own attorney that the prior approval argument has no legal basis. The injunction was denied on Friday because the judge read the agreement and reached the same conclusion. I am formally calling for a special meeting under Article 7 of the HOA bylaws, which allows 30% of households to petition for a special board meeting. I need 17 more signatures. Please respond to this post or call me directly." By 9 a.m., Marcus had 23 signatures. By 10 a.m., he had 31. More than the bylaw threshold, the petition complete, the special meeting obligation triggered under Article 7's mandatory convening provision. Dale Morrow had driven to the community gate on Saturday morning and had walked the path to assess it himself, the flooded section, the overtopped drainage channel, the clay surface beneath the water. He had stood at the flood point and had taken photographs, the water across the path, the depth visible against the fence post he had used as a reference, the surrounding field saturated and flat under the continuing rain. He had gone home and had opened his phone and had found the before and after photographs Leonard had included in the April documentation package. Photographs Dale had reviewed when the package arrived, which he had noted in his management log as complete and professionally prepared. He had posted them to the community forum at 10:30 a.m. with a caption. "These are the road repair photographs from Leonard Koss's documentation package submitted April 20th. Left column. Road condition before repair, March 3rd, 2023. Right column. Road condition after repair, April 12, 2023. The repair the board refused to reimburse. The post had gone up at 10:32. Sylvia had removed it at 10:41. At 10:43, she had sent Dale a written warning by email, a formal document on HOA letterhead, citing the management company's social media policy, stating that Dale had posted proprietary documentation to a community platform without board authorization, and that the conduct constituted a violation of his management agreement, and warning that a second violation would result in termination of his management contract. Dale had read the warning, had opened a new email, and had forwarded the entire exchange, his forum post, Sylvia's removal action, and the written warning to Vera Okafor at 10:51 a.m. with a cover message. "I thought you should have this." Vera had read it within the hour. She had called Leonard at 11:15. She had said, "Dale Morrow posted the before and after photographs to the community forum. Sylvia removed the post and sent him a written warning for posting proprietary documentation without board authorization." He forwarded the exchange to me. Leonard had said, "She warned him for posting repair photographs." Vera had said, "Photographs from a documentation package that the HOA received as part of a reimbursement claim under a public recorded instrument. The proprietary characterization is questionable at best. More significantly, the written warning creates a record of the board president using her administrative authority to suppress factual information about the repair from the community forum during an active lockout. That record is going to be relevant if this proceeds to litigation over the consequential damages the lockout is producing." Leonard had said, "What consequential damages?" She had said, "Sandra Olson's husband cannot reach dialysis. Robert Finch cannot receive a medical supply delivery. Every resident who missed work this week because they couldn't get out has a damages claim. Every resident who got a vehicle stuck in Bob Dietz's field has a damages claim for the recovery cost and any vehicle damage. These are consequential damages flowing from the HOA's decision to refuse a legitimate reimbursement claim, and from the board's failure to resolve the situation after the injunction was denied. I'm going to send Frank Citro a letter today, advising him that individual board members may have personal liability exposure for the lockout's consequential damages." She had sent the letter at 1 p.m. Frank had read it at 2 and had called Sylvia immediately. The special meeting petition had been delivered to the HOA management office at noon, 31 signatures on a single sheet, the petition citing Article 7 and requesting a special board meeting to consider payment of Leonard Koss's invoice and resolution of the road access situation. The Article 7 provision required the board to convene the special meeting within 48 hours of a valid petition delivery. Sylvia had received the petition and had called a meeting for Sunday afternoon, 24 hours after the petition delivery, the minimum notice period the bylaws allowed. Frank had arrived at the Sunday meeting 30 minutes early and had asked to speak with the board privately before the resident session opened. Sylvia had allowed it. Frank had sat across from the 5 board members in the closed session and had been direct in the way he had not been able to be direct with Sylvia alone. He had said, "I need to give the board a complete assessment of where we are." The injunction was denied Friday morning. Judge Menton read the agreement from the bench and concluded, "The prior approval argument has insufficient legal foundation to establish likelihood of success. That conclusion is consistent with what I told the board on May 16th. The prior approval argument does not work. It has not worked since the first time anyone read the agreement carefully." He had looked around the table. He had said, "Vera Okafor sent me a letter yesterday afternoon, advising that individual board members may have personal liability exposure for the consequential damages the lockout is producing. She cited a dialysis patient who cannot reach treatment, a medical supply delivery that could not be completed, vehicle damage from the farm path, and lost income from residents who missed work. If this proceeds to litigation, the board members who voted to refuse payment, twice, against my recommendation, are going to be named individually as defendants in a consequential damages claim. Directors and officers insurance covers many things. It does not always cover decisions made against the explicit advice of retained counsel, which is what the May 16th vote was." Carol Finch had said, "Personal liability." He had said, "Potentially. I am not predicting a judgment. I am telling you the exposure exists and that it grows with each additional day the gate is locked. Today is day 8. Sandra Olson's husband has missed 2 dialysis sessions. That situation alone is a significant consequential damages exposure. Tom Graves had said, "Frank, we should have paid in April." Frank had said, "Yes." Sylvia had said, "The board voted on a principle." Frank had said, "The principle is not in the agreement. I told you that in May." Judge Menton confirmed it Friday. The principle the board voted on does not exist in the text of the document it was supposed to come from. The room had been quiet. Frank had said, "I recommend the board vote today to pay the invoice. $24,750. The gate opens when the check clears. The personal liability exposure stops accruing. The special meeting residents are waiting outside gets a resolution instead of a continuation." Sylvia had looked at the table. She had said, "The board will vote." Phil Caruso had said, "Yes," before she finished the sentence. Carol Finch had said, "Yes." Tom Graves had said, "Yes." Janet Osei had said, "Yes." Sylvia had looked at the 4 yes votes. She had said, "I vote no. The motion carries 4-1. The invoice will be paid by wire transfer today." Dale Morrow had been waiting outside the closed session with the resident group. Marcus Webb, Peter Connolly, Sandra Olson, and 14 others who had signed the petition and come to the Sunday meeting. When Sylvia had opened the door and announced that the board had voted to pay the invoice, Sandra Olson had said nothing. She had sat with her hands in her lap and had looked at the floor for a moment in the specific silence of a person who had been living with an emergency for 8 days and had just been told it was over. Marcus Webb had said, "When does the gate open?" Sylvia had said, "When the wire transfer clears, today." Dale had already taken out his phone to call Leonard. The wire transfer had cleared at 9:47 a.m. on a Monday, not Thursday as originally projected, the HOA's bank processing the transfer faster than the 3-day window the management company had estimated when Dale had called Leonard Sunday afternoon to confirm the vote. Leonard had been at his desk when Vera called with the confirmation. She had said, "The wire cleared. $24,750 received in the escrow account at 9:47. I'll send you the confirmation number." He had said, "I'll go now." He had driven to the gate in his truck, the same truck he had driven on June 6th when he hung the gate, the same route down his property's southern edge to the road entrance. The morning was clear, the weekend's rain finished, the ground beginning to dry in the June sun. He had parked on the road shoulder and had walked to the gate. The gate looked the way he had left it 9 days earlier, the steel frame spanning the road width, the drop bar seated in the receiver socket, the padlock on the hasp, the signs on both posts. The road beyond ran east toward the community gate, the April repair surface visible and clean in the morning light, the drainage crossing holding the weekend's rain without subsidence, the new culvert doing exactly what it had been installed to do. He had taken the key from his jacket pocket, inserted it in the padlock, and turned it. The shackle released. He had threaded the padlock off the hasp and had set it in his jacket pocket. He had lifted the drop bar from the receiver socket, walked the gate back on its hinges to the left-hand post, and hooked the eye and hook latch to hold it open. He had stood at the open gate and looked at the road, the repair section, the drainage crossing, the community gate visible at the far end of his parcel's 340-foot crossing. The road his parcel had carried for 49 years, repaired in April for $49,500, reimbursed at $24,750, 9 days after the gate he had hung on day 46. He had taken the 2 signs off the gate posts, unscrewing them with the driver he had brought in the truck's door pocket, the aluminum plates coming off cleanly, the screw holes in the wooden posts, the only evidence they had been there. He had set them in the truck bed. He had written in his job log at the open gate, June 15th, 2023. Wire transfer confirmed 9:47 a.m. $24,750 received. Gate opened 10:12 a.m. Padlock removed. Signs removed. Road. Open. Invoice 2023-04. Paid. Matter. Pending amendment. He had driven back to the house. A car had passed him on the road heading out. A resident he didn't recognize. The car moving at normal speed through the open gate without slowing. The crossing that had been locked for 9 days now open and unremarkable. The way a road entrance looks when it is doing what a road entrance is supposed to do. The amendment negotiation had begun the week after the gate opened. Vera and the HOA's new retained counsel, a property attorney named James Okafor, who was not related to Vera and who had been recommended to the board by Marcus Webb after the Sunday vote. James had read the 1989 agreement and the full dispute record before his first call with Vera, and had told the board at his introductory meeting, "The amendment needs to address the 4 gaps that produce this situation. I want to close all 4 before we record anything." The 4 provisions had taken 3 weeks to negotiate and had been recorded as a formal amendment to the 1989 maintenance agreement on a Wednesday morning in mid-July, a 5-page instrument recorded against both parcels in the county deed records, cross-referenced to the original 1989 instrument number. The first provision was the repair timeline, an explicit pre-commencement notice period of 10 business days, during which the non-initiating party could review the proposed repair scope and cost estimate and raise documented objections. Objections had to be in writing and had to identify a specific basis in the agreement or in the proposed repair's scope or cost. The provision explicitly stated that the 10-day period was a notice and review period, not an approval period. The initiating party could proceed after 10 business days, regardless of whether the other party had responded, and the cost-sharing obligation applied to all repairs completed with proper notice. The word approval did not appear in the provision, because Vera had insisted it not appear, and James had agreed. The second provision was the joint inspection protocol, an annual road inspection conducted by both parties or their designated representatives each March, before the spring thaw, with a written inspection report signed by both parties, identifying any maintenance or repair needs observed. The inspection report would serve as pre-notice for any repairs identified in it, shortening the pre-commencement notice period for inspected items to 5 business days. Leonard had proposed the annual inspection from his own practice, the same walk he had taken on March 3, 2023, now formalized as a joint process, so that both parties would have the same information about the road's condition before any repair decision was made. The third provision was the Capital Reserve Fund, a joint maintenance escrow account funded by equal annual contributions from both parties, the contribution amount set by the joint inspection report's estimated maintenance needs for the coming year, and subject to a minimum annual floor. Repair costs would be drawn from the reserve fund first, with supplemental invoicing for costs exceeding the fund balance. The reserve fund provision meant that a $49,500 repair would never again produce a $24,750 invoice delivered to a party that had not been building toward it. Both parties would have been contributing to the fund that covered it. The fourth provision was the personal liability acknowledgement, the amendment's most unusual element, proposed by Vera and accepted by James after 2 days of consideration. Each current board member of the Hardin Cove HOA was required to sign a 1-page acknowledgement, attached to the amendment as an exhibit, stating that they had read the 1989 maintenance agreement as amended, that they understood the reimbursement obligation in Section 3(b), that they understood the 45-day payment window was a mandatory contractual obligation and not a discretionary board decision, and that they acknowledged personal awareness of the consequences of non-payment, documented in the June 2023 lockout. The acknowledgement was not a personal guarantee. It was a documented confirmation of informed awareness, the kind of document that makes a future defense of ignorance unavailable. 4 board members had signed the acknowledgement without objection. The 5th signature line had been left blank. Sylvia Trent had resigned the board presidency on the Wednesday after the Sunday vote, her resignation letter delivered to Dale Morrow, and citing personal reasons. She had not attended the amendment signing meeting. Dale had been elected interim president at the community meeting 3 weeks after the gate opened, a meeting that had drawn 41 of the 58 households, the highest attendance in the HOA's recorded history. The vote had been 40-1, the one dissenting vote being a resident who had nominated a neighbor and voted for the nomination out of courtesy when no one else seconded it. Dale had accepted the interim presidency with the specific lack of ceremony of a man who had been the most sensible person in the room for 3 months and had simply been waiting for the room to catch up. He had said, "I'll serve until the annual election in October. Between now and then, I'd like to get the Capital Reserve Fund established and the annual inspection scheduled for next March." Marcus Webb had said, "Dale, I'd like to nominate you for the full term in October." Dale had said, "Let's get through the summer first." The amendment had been recorded on a Wednesday morning in the county deed records, instrument number assigned, cross-reference to the 1989 agreement, running with both parcels in perpetuity. The 4 new provisions were in the county deed records, alongside the original cost-sharing framework, the notice requirement, the documentation requirement, and the 45-day reimbursement window that had been there since 1989 and had said what it said for 34 years before a board president decided it said something else. Leonard had received the recorded instrument confirmation from Vera on Wednesday afternoon. He had opened his job log and had added 1 line to the June 15th entry. Amendment recorded July 19, 2023. Matter closed. He had closed the log and set it on the shelf beside the 1989 maintenance agreement. His 2004 copy, the margin note on Section 3 still legible in his handwriting from the day he had first read it, 19 years ago. Notice required, not approval. It had always said that. It still said that. It would say that for as long as both parcels stood. Leonard had walked the road the morning after the gate opened. Tuesday, June 16th. The air clear after 9 days of intermittent rain. The ground beginning to firm under the June sun. The road surface drying from the edges inward, the way a well-drained road dries when its base is sound. He had started at the western end, the gate standing open against the left-hand post, the hook and eye latch holding it back, the road entrance open and unremarkable in the morning light. He had walked east from the gate along the road's southern edge, the same direction he had walked on March 3rd when he had assessed the winter damage. The same route he had walked every time he had evaluated this road in 19 years of ownership. The western section's surface was clean, the 180-foot repair length running east from near the gate, the new asphalt overlay smooth and uncracked, the aggregate showing the tight surface texture of fresh mix that had seated properly under traffic and weather. The map cracking that had covered the western section in March was gone. Not patched, not bridged, gone. The base beneath it excavated and recompacted, and the surface rebuilt from the subgrade up. He pressed his boot into the surface at the point where the worst cracking had been. Nothing moved. The base was sound. The frost heave ridge in the middle section was gone. The surface ran level across the full lane width, where the diagonal heave had been. The correction visible in the way the road shed water evenly to both sides, rather than deflecting it to the south shoulder. He had watched that drainage pattern from his truck during the weekend's rain, and had noted it in his log. The repaired section draining correctly, the original design intent restored. The drainage crossing had been what he had come to see most specifically. He had stood at the crossing and had looked at the road surface above the new culvert, the surface he had watched subside 4 inches in March, the surface that had been collecting water and worsening with each vehicle crossing when he first photographed it on March 3rd. The surface above the new culvert was level with the surrounding road, the correction exact, the subsidence completely eliminated. The weekend had given the crossing its first real test. 2 inches of rain on Friday, more Saturday, the drainage channel running full, the culvert carrying the flow. He had checked the culvert outlet on Sunday when the rain stopped and had found it running clear, the full pipe diameter in use, the flow clean and unobstructed. He had crouched at the road edge and looked at the culvert inlet from the drainage channel side, the new 30-inch high-density polyethylene pipe, the bedding gravel visible at the inlet's edges, the inlet end clean and open, no debris accumulation, no signs of the partial collapse that had brought the road surface down above the old pipe's failed section. The inlet was exactly what a culvert inlet was supposed to look like, open, clean, doing its work without drama. He had stood and looked at the crossing from road level, the surface above the culvert flush with the approach on both sides, the drainage channel running below, the road carrying the load it had been built to carry. A 9-day lockout, a denied injunction, a 4-to-1 board vote, a farm path flooded in a hayfield, a dialysis patient who had missed 2 sessions, a retired contract attorney who had pulled the agreement from the county records on a Saturday morning and found in 30 seconds the thing that wasn't there. All of it because a board president had read a notice requirement and called it an approval requirement. The road had not changed. It had been a failing road in March, and it was a repaired road in June, and it would be a sound road in October when the annual inspection was scheduled, and both parties would walk it together and write down what they found and sign the same piece of paper. That was the amendment's design, the same walk Leonard had always taken, now taken jointly, the information shared before any decision was made. He had pulled his contractor's job log from his jacket and had opened it to the June 15th entry, the gate opening, the padlock removal, the wire transfer confirmation. He had uncapped his pen and had written below the July 19th Amendment notation in the space remaining on the page. June 16, 2023. Road walked. Full repair section. Gate to HOA boundary, west to east. Surface. Sound, no cracking, drainage correct. Drainage crossing. Culvert performing. Inlet clear. Road surface level, no subsidence. Base, confirmed sound. Repair, complete and holding. He had paused and had looked at the crossing one more time. The pipe, the surface, the drainage channel below. Road repaired. April 12, 2023. Invoice submitted. April 20th. Invoice due. June 5th. Invoice paid. June 15th. Gate installed. June 6th. Gate opened. June 15th. Lockout duration. 9 days. Injunction. Denied. Amendment. Recorded July 19th. He had written the final line at the bottom of the page. The agreement said what it said. It always did. He had capped the pen and closed the log. A car had appeared at the community gate. A resident heading out for the morning, moving at normal speed down the road toward the open gate. The tires crossing the drainage crossing without slowing. The road surface holding clean under the weight. The culvert below running clear. The car had passed through the open gate onto the county road and turned south without stopping. Leonard had watched it go. He had walked back to the truck, set the job log on the passenger seat, and driven back to the house. The gate was open at the road entrance, the drop bar resting in its cradle bracket, the padlock absent from the hasp. The signs were off the posts. The road was open and repaired, and the invoice was paid, and the amendment was in the county deed records running with both parcels. The 1989 maintenance agreement still said what it said. It had said it for 34 years before anyone had suggested otherwise, and it would say it for 34 more.